Hi, and welcome to the second part of our three-part series on brands versus trademarks. Today's session, we will be covering jurisdictions such as China, India, Malaysia, and Singapore, and specific focus on the registration process, preparing for registration, and obtaining registration in these countries, as well as steps to be taken by brand owners after registration is complete. I hope you enjoy our session today, and please share any feedback that you have. Thank you.
If you are a foreigner or a foreign company or foreign organization, the first step is you have to engage your local trademark agent. You can't file directly as a foreigner. So once you engage your trademark attorney, you need to work with your trademark attorney to confirm some issues. The typical one is whether you can claim any priority, 6 months priority, and what trademarks and what classes and what subclasses you want to file, and whether you need to do any search at all before you file, and whether you need any detailed advice before you file. Once you've done that, and the next thing is to prepare for the application documents. That includes application, the signed power of attorney, and the signed certificate of incorporation and the trademark sample. Once you've done that, then you're ready to file.
So the very first step is to identify a brand or logo which is distinctive and unique, as we discussed earlier. And a coined or invented mark has a maximum potential of becoming a good brand, which can go a long way for a business to create an identity for their products. While it's prudent to register your brand names before you launch your product, businesses should utilize this preparatory stage to look into other important steps before they can apply for registration. For example, to identify the class or classes the trademarks would fall under. India has adopted the NIS classification, and there are 45 classes which a person can apply for registration. The classes applicable to the trademark application would depend on the range of products and services being offered by the businesses. Then is to carry out a public search for same or similar marks to mitigate the risk of an objection from the trademark office or a potential opposition from a third party. It is important to carry out a proper search in the right classes, but if we want a more holistic view, we could carry out a search in all the 45 classes. In India, trademark searches can be carried out online on the government's intellectual property portal, and a search carried out on this platform gives you details of trademarks that have been applied for or that are already registered in India. But quite a few businesses do not register their brands, and therefore our search should not be limited to trademark office records alone. It would be prudent to carry out a search on the internet to check for same or similar marks being used domestically for other products and services. Prior use of the mark is not a prerequisite for applying for registration in India. An applicant may choose to either claim a date since it has been using the mark, or assert that they are proposing to use the mark in the future. In case the applicant chooses the former, an affidavit supporting the claim of prior use would need to be filed with the application. Lastly, the applicant may choose to file the application himself or appoint an attorney to handle the process by granting him a power of attorney for the registration process.
In Malaysia, it is, I think, pertinent. We always advise our client to launch a search with the Malaysian IPO IP office, which are available online. This is to check and mitigate opposition by the registrar to ensure that the trademark is able to be registered. We will usually prepare a due diligence report and notify our clients on the success rate of the mark or the device mark, upon which we will prepare a statutory declaration. Most jurisdictions will refer it as a power of attorney, but in Malaysia, we will need an SD. We will sign it, just some basic information, the owner of the trademark, the trademark to be attached with the SD, the details, whether it's going to be a company or individual as the owner, the correspondence address, and the trademark agent's particulars. After that, we will attach it with a form which has been prescribed by the IP office, and the registration will start off from there on.
Right. Hello, everyone. This is Renee from Singapore. So in the jurisdiction of Singapore, it's actually very easy to complete an application form. So we advise, just as how Wei Sin mentioned, while it takes only 10 minutes to complete an application form, it is very important that you have a good trademark protection strategy in place, as mentioned by Wei Sin and my other colleagues as well. So what must you consider for this trademark protection strategy? Number one, I would always look into the applicant. Who exactly is going to be the applicant? Is it the individual who created the mark, or is it the company? Right? So this is because the applicant becomes the owner of the mark, and registration is evidence of ownership. So who is to own the mark is a very important question. There's also tax implications, and you may want to consider whether documentation like joint ventures and relevant shareholders agreement take all this into consideration as well. Then you need to decide which version to file. Select the correct version, and usually you must file the version that you will be using. Okay. Now in Singapore, there is a need to use the version that was registered within 5 years of the date of registration. So that is another reason why you must go for the version that you will be using. Don't file a particular version and then use a different version. Singapore also has got color and black and white series. So those are things you need to know to broaden your trademark protection. Select the correct class. What is the brand going to market? Is it just products? Is it just services? What are the products? What are the services? And then drill down to the actual items. In Singapore, our classification is incredibly broad. So if you were a stationery, for example, if you were selling stationery, you do not need to actually drill down to pen, pencil, eraser, all the details. You just need to file it for stationery and it would cover. Now you may also need translation. If your mark consists of a non-English word, then you will need to include a translation. So you want to make sure that your word doesn't have a descriptive meaning in a different language. Priority claim is already covered earlier by one of our colleagues. So in Singapore, we don't need any documentation. There's no need for power of attorney or SD or anything like that. All we need is a JPEG version of the mark. Right? And we do not require prior use, nor do we, all that is required is there is an intent to use the mark in order to file for it in Singapore. Thank you.
I think we're probably talking about 3 scenarios. One is the registration will be going through smoothly without any rejections or oppositions. The second scenario is if it's rejected by the China Trademark Office. The third one is if there's somebody opposed it during the Gazette period. So we talk about 3 scenarios. Let's start from the first one. The first one is smooth registration. So we filed the application, as we said before, and then the China Trademark Office, where you record CTO, will go through the formalities to have a look at whether documents all comply with requirements. If yes, they will issue you with a certificate acceptance notice. And once you've done that, CTO will move into the real examination. At that stage, if they come to the view that your application meets the requirement, then they will gazette the trademark, and that gazette period is 3 months, assuming that there's nobody object to it. And by the end of that period of time, the CTO will issue the certificate of registration. Now, the second one is start with filing. You file, the CTO accept your documents, and then they move into the examination stage. Then CTO is formed the view that the application doesn't meet its requirements, so they reject that. And there's 2 situations, 2 results. One is you say, right, that's it, and I'm now going to challenge it, and then your application becomes invalid. If you object to it, you can file your re-examination request to ask the government to review it, to have a look, see whether your application can be accepted. Now, if the government authority is of the view that your objection or your request for re-examination is successful, then the CTO will move into the preliminary approval stage and gazette it for 3 months. And then at the end of that, you get your certificate of incorporation, a certificate of registration. Now, the third scenario is CTO accept your documents and moving to the examination stage, and then gazette your trademark for 3 months. During that period of time, somebody objects to your application. Then that could be 2 results. One is the CTO will look at the objection or opposition and decide that your application should go through, and then they will issue the certificate. And if not, they will object your application, then your application becomes invalid. Then, of course, after that, you can appeal for their decision, and then, of course, followed by court actions.
In India, trademark applications can be filed online through the government's comprehensive e-filing system or by physically submitting the application at the trademark office. India has 5 trademark offices situated at New Delhi, Mumbai, Chennai, Kolkata, and Ahmedabad. Based on the applicant's address, the territorial jurisdiction of the office would be determined for processing the application. Once filed, the application goes through formalities checks for preliminary issues and Vienna codification of the figurative elements of the trademarks. Once the codification is completed, the application will be allotted to an officer at the trademark office. The officer would then review the application for correctness and issue an examination report. The officer has the ability to accept the application or object by highlighting the grounds under the provisions of the Trademark Act. If objected, the applicant has a right to respond to the examination report and also appear before the officer to address the objections raised by him. If the officer is satisfied with the justifications and the proofs provided by the applicant, he may pass a favorable order. Else, the applicant has a right to appeal the decision before the Intellectual Property Appellate Board. Once a trademark application has been accepted by the trademark officer, the proposed trademark is published in the Trademark Journal. The journal is published weekly and contains all the trademarks that have been accepted by the trademark offices across the country. Upon publication of the trademark in the journal, the public has an opportunity to oppose the registration, and if there are no oppositions filed within 90 days of that publication, the mark will be registered. This whole process typically takes about 6 to 12 months before the applicant has a registration certificate in hand.
So in Malaysia, the registration process used to be about 15 to 24 months. The Malaysian IPO office have now dropped it with a target of 6 to 9 months, reducing the formalities, which are basically now when you want to register a trademark, you only use one form as opposed to 2 forms earlier on, as opposed to earlier on waiting for an opposition process, then to file the forms in furtherance. But now, all you need to do, your agent will need to file 1 form, and if it's a smooth process, it will take 6 to 9 months. The registrar will verify the mark, and of course, he has the discretion to object to the registration, and objection will be notified to the trademark agent. A time frame will be fixed for submissions, and if the submissions are accepted, then the registrar will proceed to register the trademark. However, if the submission is rejected, then the applicant can pursue the registration process through a hearing before the registrar. And upon failure, in the event if there's a further failure, probably the applicant may want to choose court as the forum to contest the opposition. So basically that is the registration process in Malaysia.
In Singapore, there are 4 main stages of a trademark application. So initially you file the application, and when you file your application, you immediately receive your application number. So Singapore has done away with providing you with a filing receipt, a formal filing receipt. Okay, you will immediately receive an application number through your official fee payment receipt. And you also have an opportunity to reserve your brand domain name for up to 6 months. You have to do that at the point of filing your application. You can actually say, I want to reserve the brand name domain name. Okay, that's for 6 months. Then it moves on its own. So you don't have to do anything else after you're filed. It will move into the examination stage. Here, the examiner will examine, first of all, the formalities of your application, if you got everything right. And then after that, substantively. As in our first series, what do they examine about? About availability, is there anything similar? And about distinctiveness. If an objection is raised, the applicant can actually dialogue with the examiner informally as well as formally. Now, if the objections are all cleared or there were no objections at all, the application then moves to the acceptance stage. We will receive a notice saying that your application has been accepted after being examined. And then it immediately, within the day, it goes into publication. In Singapore, publication is for 2 months. Right? And during this 2-month period, third parties can oppose if they feel that their rights are being compromised. If there's no opposition, at the end of the 2-month publication period, the certificate of registration is issued. So the entire process, I would say between 5 to 9 months.
In China, there's a lot the trademark owner can do. The first and the most important one is to use the trademark in the way it's registered. I think Renee already mentioned that. It's really important. You register that, and you should follow that and use it. And also, you should keep a proper record of the trademark use evidence in case you were attacked by somebody 3 years down the track. In China, anybody can can apply to cancel your trademark registration on the ground of non-use after the registration is done for 3 years. So that's really important. If you don't use the mark, or if you use the mark in a different way, that can be serious consequence because you can't prove that you've used the mark properly. Another one is if you change the format, trademark format without registration, that could subject you to administrative penalties. And in the worst scenario, the trademark office can revoke your registration. So that's number one. Number two is you need to monitor whether there's any identical or similar trademark applications. And that include similar trademarks on key goods and identical marks on highly relevant goods. And the third one is to monitor infringement. You have to act actively to make sure that nobody have infringed your mark. You are the one who really need to do it. You can engage agent to do it, but it's your responsibility to make sure that your mark hasn't been copied by anybody else. Another important thing is you need to update the registration records if there are any changes to your name, your address, or the address of your agent. And that's really important. Another important thing you need to do is to record your trademark registration with the China Customs if you want to stop the infringement goods leaving China. And the last one is really important, a lot of people tend to forget, is remember to renew your trademark registration. The term of validity of a trademark registration is 10 years, and 10 years can go very quickly. So you should renew your trademark within 12 months before the expiry date. There is a 6 months grace period after the expiry date, but if you renew that during the grace period, there could be extra government fees incurred. So it's quite important to remember to do it.
Once the trademark is registered, the applicant can start using the symbol of R in a circle as a prefix to the trademark, signifying that the trademark now has statutory protection. Trademarks in India are valid for 10 years from the date of application and not registration. So therefore, the applicant should renew the registration prior to expiry of the term to ensure that the mark is protected in perpetuity. As trademark registrations are territorial in nature, a mark registered in India is enforceable in India alone. Therefore, if a business is inclined to sell their products abroad, it is highly recommended that they also register their trademarks in each of the potential countries as soon as they obtain a registration in India. These international filings can be made directly in each country or by using the Madrid system. If you choose the Madrid system, a prior registration of the trademark in India is a mandatory requirement. Making an application in a reciprocating jurisdiction within 6 months from the date of your registration can give you the advantage of priority rights, which basically means that if the trademark is accepted in that foreign country, the registration in that country will be backdated to a date on which the application was made in India. Now, a common mistake a lot of business owners do is that they think once the trademark is registered, they are protected, and no one can register a conflicting mark in the future. However, there is a possibility that a trademark officer does not see a conflict and allows a new trademark application to be processed in the same or different class. This scenario can best be mitigated by watching the trademark database for possible conflicts, which gives you a chance to oppose the applications filed by other applicants. You may choose to monitor the trademark journals yourself or engage professionals to render a trademark watch service.
In Malaysia, upon a successful registration, the trademark office will issue the applicant with certificate, and the certificate, the tenure is 10 years. A trademark is valid for 10 years. And I think one common mistake some smaller SMEs do is that they do not monitor or keep proper records of their the tenure of trademark. So often than not, sometimes I have come across that the owner of the trademark tend to lose sight and forget to renew their trademark. So that's something which I would like to highlight. And of course, just like my colleague in China have said, non-use is also an issue in Malaysia. I think it's pertinent for the applicant to constantly use the trademark, failing which opposition can be made by way of a court application to invalidate the trademark. Yes, so basically managing the trademark from the office by the applicant is the most important as far as I'm concerned.
Right, so for Singapore, I would say there are 6 points for you to take note of once you have your certificate of registration. Number 1, as mentioned by all my colleagues, use it and use it correctly in all your marketing collaterals. It's very important to apply it exactly how you filed it. Number 2, keep evidence of use, right? So what kind of evidence is required in case there is a challenge on that mark or you want to enforce your rights? The date of first use. When did you first use your mark? In Singapore and anywhere in the world. What is your sales turnover like, globally as well as in Singapore? How much have you spent on advertising and promotion? Keep your invoices, copies of them, and make sure your invoices contain the mark itself. Then, details of your domain name registrations. A domain name registration can help to challenge a third party's trademark application of a similar mark. Now, point number 3, don't forget to look for collaboration opportunities once you have a registered mark. You want to create licensing revenue. That is what IP assets are all about, for you to generate income. So look for collaborating licensing revenue, maybe through franchise, through licensing, through joint ventures, spin-offs. And then make sure you record any license that you enter into. Point number 4, monitor for infringement and enforcement. It's very important to maintain your mark and your reputation and credibility. That's what a trademark does for you. Point number 5, update your records regularly. If you had a company change of name or a change of address, an assignment to another company, ensure all these are updated with the registry that your mark is registered with. And point number 6, monitor your renewal date. Like in all the other countries, trademark registration is for 10 years in Singapore, and it can be renewed in perpetuity. Just keep renewing it every 10 years.